I'm Maya Van Rossum. I'm the Delaware Riverkeeper, and I didn't realize that the film already ran, so I apologize. I'd like to welcome you here this evening on behalf of the Delaware Riverkeeper Network, and we are very pleased to be here with you to talk about the Supreme Court ruling in the case Robinson versus the Commonwealth. There have been a lot of wonderful things said about this legal decision. One newspaper wrote that the state Supreme Court ruling in the Act 13 case was a historic victory for protecting Pennsylvania's environment. Another newspaper wrote that this may one day be seen as the most important environmental decision ever written by an American jurist. No matter how this case is described, the Delaware Riverkeeper Network and the 7 towns that pursued this legal action are proud of the outcome. Amongst the towns that joined us in this legal action were the Township of Nockamixon and the Borough of Yardley from Bucks County, the Township of South Fayette from Allegheny County, Peters Township, the Township of Cecil, and Mount Pleasant Township from Washington County. And the Delaware Riverkeeper Network is pleased to have the opportunity for the first time to bring together the legal team and some of the community leaders that brought you this important legal decision. And this is the first time that we are all coming together to speak about it as a team. Of course, we're going to have with us this evening our auspicious legal team of Jordan Yeager, John Smith, and Jonathan Kamen. We're also joined by some of the original petitioners, by David Ball from Peters Township, as well as myself, the Delaware Riverkeeper, and also in my capacity as the head of the Delaware Riverkeeper Network. And I do want to say that the Delaware Riverkeeper Network was the only environmental organization that was part of this legal action, so we're very proud of that. We're also going to be joined by Professor Dernbach. Now, while Professor Dernbach was not part of the legal team that pursued this legal action, he has written extensively about the Environmental Rights Amendment, and he was cited repeatedly by Justice Castile, who wrote the plurality decision. So we believe that Professor Dernbach was really vital to the outcome of this case. We are sad that we're not joined by Brian Coppola from Robinson Township or Dr. Kahn, but I want you to understand, even though they couldn't be with us here this evening, we acknowledge the very important role that they played in this legal action. Of course, I would be remiss if I didn't thank the funders of the Delaware Riverkeeper Network, the funders that support us year in and year out, including our members, who make the donations that make it possible for us to pursue these kinds of legal actions. And I do specifically want to thank the Civil Society Institute, who provided the funding for tonight's forum so we could really help spread the word about what has happened here in Pennsylvania. Before we go on to the forum, I do want to just tell you a little bit about the role of the Delaware Riverkeeper Network. For the Delaware Riverkeeper Network, when the Pro-Drilling Act 13 was passed, our challenge, our legal challenge to that piece of legislation was really an imperative. We had worked very, very hard for many years to protect our communities from shale gas development. We've had wonderful success in the Delaware River watershed, where we secured a moratorium that for now protects us from shale gas development. Of course, it's a moratorium that we have to fight daily to keep in place, because just a vote of 5 individuals could lift that moratorium. We also have worked for many, many years with growing success throughout Pennsylvania and throughout the nation, working with our environmental colleagues and other organizations and citizens on the ground to provide growing protection to the communities that have been targeted by the shale gas industry. If Act 13 had been allowed to stand as it had been written, it would have put a lot more communities in the path of harm. And it also would have removed and threatened a lot of the very, very important protections that the Delaware Riverkeeper Network and other organizations working on the ground had secured. So it really was vital that this legal challenge be pursued, and it was vital that the Delaware Riverkeeper Network be part of that legal action. Of course, we are very pleased that as a result of the court's decision, that many of the most devastating elements of the Act 13 piece of legislation were declared unconstitutional or will continue on the legal path and be potentially undermined by the courts. But the fact that this decision isn't going to just provide protections from shale gas development, but really is going to impact all actions in the Commonwealth by public officials that could impact our environment, is just really gratifying beyond belief to all of us at the organization. It's also a wonderful development for us because 2013 marked the 25th year of the Delaware Riverkeeper Network fighting to protect our Delaware River. So to secure this decision at the end of that 25th year was really a wonderful way, we feel, to show the community the important, successful work we do for protecting our river and for protecting our communities. But also for the Delaware Riverkeeper Network, this decision and this success was kind of a coming of full circle, because one of the first things that we did as an organization 25 years ago was craft the legal petition, submit it, advance it, fight for it, that after many, many years of debate resulted in something called the Special Protection Waters Designation for the entire non-tidal Delaware River. That's 197 miles of Delaware River. This Special Protection Waters Designation has resulted in a lot of high-level protections for the river on a variety of fronts, not the least of which it was the foundation for the moratorium against shale gas development that currently protects us. So it really was a coming of full circle. We began as an organization putting in place a protection that protected our watershed from shale gas development, and after 25 years, we secured with the 7 towns a legal decision that is going to increase that level of protection with regards to shale gas development and far beyond. Of course, for the next 25 years, we're going to continue to work on a lot of issues, including shale gas development, but I did want to announce one new project here tonight. The Delaware Riverkeeper Network is announcing for the first time in public the Generations Project. And this is a project that's going to be about ensuring that the Pennsylvania Supreme Court pronouncements are honored here in Pennsylvania, but that also this legal decision can serve as an inspiration for environmental constitutional protections across the nation and perhaps even at the federal level. So we're really looking forward to making the most of this legal decision that we all have worked so hard to secure. With that, I want to jump into our forum for tonight. Just explain how it's going to work. We're going to have 3 panels. Each panel is going to have 3 speakers. And they're each going to be talking about some aspect of the case, how it came to pass, what it means for our communities, and what we need to do in the future to make it a reality. After each panel, we're going to have 5 minutes of question and answer. And then once all of the 3 panels have gone, we're going to bring all of the panelists up on stage, and we're going to have 15 minutes of Q&A just to round out the evening and try to get to all the questions that we hope will be submitted tonight. If you are here in the audience, you can submit a question by writing it on the index card that you found on your chair and handing it to members of my staff that will be walking around collecting them. If you are out in the ether world watching via webcast, you can also submit questions. Just email them to questions@DelawareRiverkeeper.org, and members of the staff are going to be going through them and passing them up to me as moderator for the first half of the session. And for the second half of our session, Tracy Carluccio, the Deputy Director of the Delaware Riverkeeper Network, is going to come up to this spot, and she's going to be moderating the second half of our forum. One more thing that I have to announce that I just learned. If you are wanting to get Pennsylvania CLEs, you have to fill out your form and leave it at the front desk so that it can be submitted tomorrow. If you are trying to get CLEs from another state, you can fill out your form, but you have to mail it in on your own. And so with that, I want to jump into our first panel. Our first panel is going to be focused on how and why did it happen. And our first panelists are going to be David Ball. David Ball is a councilman in Peters Township, which is located in the middle of very intense drilling activity in southwestern Pennsylvania. David Ball recognized very early on the threat that Act 13 posed to municipalities, and he was very proactive in trying to change or prevent its passage. He was a key litigant in the Act 13 case. We also have on our first panel John Smith. John Smith is a partner and co-founder of the law firm of Smith & Butts. John has been at the forefront of oil and gas issues, and as a solicitor of Cecil Township, John has worked to create one of the first comprehensive oil and gas ordinances in southwestern Pennsylvania. John was one of our lead attorneys in our action against Act 13, and he focused his energy on the due process pieces of the argument. And then we have our third panelist is Jonathan Kamen, and he's co-managing partner of Goldberg, Kamen, and Garvin Law Firm. Jonathan concentrates his practice of law in the areas of real estate law, land use litigation, and municipal law. And while he is very active in the legal world, if you know anything about John, you know that he is also very, very active in his community and in the charitable world. Jonathan was a very important lead player in our Pennsylvania Supreme Court, and he took the lead on our special law and eminent domain claims. And with that, I'm going to turn it over to our three panelists.
Okay, thank you. Thank you, Maya.
Do you want us up there, David, or want us here? Maya, do you have a preference? You want us here, or do you want us up there?
No, I'd like you there.
Okay, there you go.
Okay, no problem. Great. Well, anyhow, it's really nice to be with you guys this evening. It's a pleasure to be back in Philadelphia. My piece of this is to talk a little bit from an elected official's perspective of how we got to the point of having to sue the great Commonwealth of Pennsylvania. For us, go back a little bit, drilling started in Washington County, where I'm from, in 2005. And between 2007 and 2009, there was a real, feeding frenzy, if you will, of leasing activity. The landmen were around leasing every piece of property that that looked like it, could have a drill rig on it, and some that couldn't. And in any case, large-scale drilling started in our area in 2009, and Washington County was ground zero. I mean, that's where the initial activity was. We looked around as township officials and said, okay, with all of this leasing activity going on, sooner or later, drilling is going to follow. So we said, where are we in terms of protecting the residents of our community and protecting our environment and our community in terms of our local ordinances? And we said, we're not. We didn't really have any ordinances that specifically addressed gas drilling. So with that high level of interest and the high level of activity going on, after a tremendous amount of debate, many public hearings, we finally in Peters Township passed a gas drilling ordinance in August of 2011. For our township, if you have 5 people to a public meeting, it's a monumental event. We had regularly, if gas drilling was on the agenda, we had 150 or 200 people, to the point we had to have auxiliary rooms and TVs. So that was the level of interest in the township. And in any case, the intent of the ordinance that we did pass was, as well as those of the surrounding communities, was to be fair to everybody. We wanted to be fair to our citizens as well as the people who owned gas leases. I mean, they have a right for the economic development of their property. So we tried to be fair to everybody. So during the fall of 2011, when Senate Bill 1100 and House Bill 1950 were being debated in the legislature, it really became apparent to those of us that were watching that this was not good. Things were not going well in terms of protecting the citizens of our townships, and so that they were seriously at risk. So several township officials in the Washington County area around Peters, Brian Coppola that Maya referred to, and Andy Schrader were two that particularly worked with us, and Darren Gabriel and Fayette. We spent an awful lot of time lobbying our legislators. Brian and Andy and I made a number of trips to Harrisburg. We wandered around the halls of the legislature talking to anybody that was willing to talk. We talked to the lieutenant governor a couple times. We spent a lot of time on the phone with emails, meetings, speaking at events. we made a presentation at the PSATs, the Pennsylvania State Association of Township Supervisors. We made it at their convention. We had a unanimous resolution that essentially said 1,500 communities joined us in saying this was not a good thing. So, you know, this was not the 7 dissident communities that you read about in the newspapers sometimes. You know, those of us that had our knickers in a twist, I think was the term. In any case, while House Bill 1950 was being voted on, we were literally on the telephone with our legislators on the floor of the House, talking to them and trying to talk to other people to make sure that we got as many people as we could to vote against this piece of legislation. The bill, as we're all aware, passed by 10 votes. I think if we'd have had another week or two, it probably never would have passed. We were making a lot of headway, but it was voted on. That's what it was. You know, why did it pass? My personal opinion is that I think our legislators were fixated on fees. That was the bright, shiny object that was dangled in front of people, and they didn't really think about, look at, or in some cases care about the rest of this piece of legislation. Every time we read this bill, we found more to dislike in it. And I think that between John and I, definitely every time we read it, we found more things. And I can't believe that our legislators actually read this thing. But in any case, after reading and rereading this bill, we knew, it became apparent that the state was saying to us that they knew more about our communities than we did. They knew more about what was good for the citizens of our communities than we did. They knew more about where our communities were going in terms of our plans for the future than we did. And they cared more about the gas industry than they cared about the citizens. That much was apparent. So Act 13 said all of those things, and we disagreed. Worst of all, the bill violated the rights of our citizens, and that's where we really and truly got into the legal piece of this. We did not file suit against Act 13 because we didn't like it. We filed suit because Act 13 contained multiple violations of our Constitution and the rights of our citizens. Act 13 was not only outrageous in the provisions of the bill, but it was blatantly illegal. So that's why we filed suit. More to the point of local officials, Act 13 put local officials in a very, very difficult position, if not an impossible position. It required us to either violate the law of the state and not follow what Act 13 required us to do, or violate the Constitution, because the two were diametrically opposed. So we had it was a lose-lose situation. And each and every public official swears an oath when they're elected. You can put up that first slide. See, I'm the only one that gets to say that. Everybody else has to hit a button. Everybody that's elected to an office takes an oath to uphold the Constitution of the United States and the Commonwealth of Pennsylvania, and to discharge those responsibilities with fidelity. Those of us that chose to fight Act 13 did so because we take that oath seriously, and we wish that our legislators had. Thank you.
Thanks, Dave. Under my part, which Maya put together, and first of all, Maya, thank you and the Riverkeeper for bringing us all together. It's been a while since we've all been in one room, maybe since the injunction hearing, or maybe the Supreme Court. But the title of what they would like us to discuss is, John and I, The Legal Challenge Unfolds. So a little bit of behind the scenes, Dave Ball, Brian Capola, Andy Schrader, you talking Peters, Robinson Township, Cecil Township, South Fayette Township, coming together, say, okay, now we're stuck with this law. Governor Corbett signed this law February 14, 2012. Just so happened Robinson Township had a meeting that night and voted to challenge the law. Well, it was a great idea, but of course we weren't going to challenge it, as Dave said, just for the sake of crying because we didn't like it. That we were some upset communities looking for some political gain, that, hey, there were communities out there that are against this. So what we needed to do is try to confirm whether this statute violated any provisions of our state constitution. And I will tell you that most doors said no. I mean, you talk to any lawyer, they said the state can tell local governments whatever they want and you have to follow. That was the mantra, that's what the law said, and we disagreed. Within a week, for the first time, I met Mr. Kamen at Lafayette. When we sat down and talked about the case, both John and I agreed that municipal officials had an obligation under the law to protect the health, safety, and welfare of their citizens. And this law specifically said you cannot do that anymore. And we knew it was problematic. So probably within a few days, we were in contact with Jordan Yeager. Now, the three of us had never met. So the three lawyers that tried this case had never met prior to this case. And we all got in a room in a conference call, and I remember David was there, Brian, some elected officials, because they also didn't want to put their name behind a lawsuit that they believed was frivolous. And John and I and Jordan came up with a number of different claims to bring. And Jordan always, almost I could see it on his t-shirt, Article 1, Section 27, was Jordan's mantra. And the case law wasn't with Jordan, but as he discussed it with us, you know, we weren't going to put our names to something we didn't believe in. And we believe not only in Jordan, we believe that Jordan had made a colorable argument that this could work. And we came up with a number of different arguments. Then it was who was going to bring the claim. So the municipalities we talked about, we also wanted, it was a statewide issue. So we wanted to make sure that the western part of the state also teamed up with somebody from the eastern part of the state. And that's where Jordan came in with Nockamixon and Yardley. There were a number of other municipalities that wanted to get involved, but it got a little bit unwieldy after that because we had 7, and with the Riverkeeper and Dr. Kahn, and David was a plaintiff as well, and Brian Coppola. As John told the court the first day when they said we don't have standing, he said, who did we not bring as a plaintiff? We've got individuals, we've got municipalities, we've got, who isn't there? And they didn't have an answer for that. Ultimately, they all were found to have standing. Now, what's also important, and Dave didn't bring this up, is at the local level, this was a bipartisan issue. The 2 named elected officials are both Republicans. Dave's board has 7 members. They're all Republicans. Brian Coppola is Republican. These were not Democrats crying against a Republican bill. These were people on the ground crying against a law that was clearly unconstitutional, saying challenge it. So as it unfolded, when we had a conference call, we saw that there were a number of issues that we could raise. I think we ended up raising 14 counts. We had 30 days to get an injunction filed with the court. So in order to get the injunction filed, we had to draft a complaint. Now the complaint was longer than anyone will ever know because we thought for certain that if we may get one look at this. So we almost drafted it, Jordan, if you recall, as a summary judgment. We put case law in it. We cited state. We anticipated a lot of the arguments that might have been filed. So in that, we were told that by professors, we went a lot of different places. We didn't have a claim. We ended up bringing a few claims. Now, I'll make sure if I can, is this working, Mia? I'm trying. Did it go? This is a picture of Robinson Township, the named party. This is a drill site in Robinson Township that went awry before the lawsuit was filed. This is a leaking well site. 60,000 tons of contaminated soil were removed from this site. And the reason I put this quote up, and this is from the Chief Justice of the Supreme Court, the type of constitutional challenge presented today is as unprecedented in Pennsylvania as is the legislation that engendered it. And why that's important is there was no template. When the 3 of us sat down with our staff, Kendra Smith, Jennifer Scafoni, Lauren Williams, everybody sat down and said, how can we attack this? There was no, as lawyers, we always like to look, has somebody done this before? Is there case law? There wasn't anything. So what we did was novel, but we all stood behind it out of the gate. Let it go. This is a compressor station in Mount Pleasant Township, one of our other plaintiffs. Mount Pleasant Township is where the first Marcellus well was drilled. So they were important to have as a plaintiff in this case. They have over 100 Marcellus wells now, multiple compressor stations, multiple frac ponds, miles and miles of high pressure line. This is where it all started. And this quote from the court also I thought was appropriate for this evening. It says, according to the citizens, and I think Dave spoke to this dispute is not about municipal power, statutory or otherwise, to develop local policy, but it is instead about compliance with constitutional duties. Unless the Declaration of Rights is to have no meaning, the citizens are correct. So that loss, when we read that, of course, when we read the opinion, which John and Jordan will get to, I think there was more relief because we knew we couldn't lose this thing. If we lost, living in the communities where drilling was taking place, we knew what was going to happen. They would drill everywhere. And you think about it, there is gold under your feet. They're going to get to the gold. And the setbacks were not enough to keep them out of communities. We made a number of different arguments. The due process argument was accepted by the Commonwealth Court and Justice Baer. The special law argument was remanded back to the Commonwealth Court to deal with. And, of course, the argument on Article 1, Section 27, the plurality, the 3 members of the court found in that favor. So everything we came up with was a legitimate argument that the court found had a basis to look at this law. So as we go on, John's going to talk about when we got to the injunction and then from there, and we'll go back to the panel discussion. John? Let me go back to there. Next one. Next. Back up.
So one of the things I do want to say is that this really was a tremendous effort from the team, and John Smith was our leader on this. And he really was the one who came and rang the alarm bell for everybody to understand the impacts of this. And the reason why I want this slide up during my presentation is because when we saw these pictures, and again, as John said, this is in Robinson Township, the question before us was, is this something that you really want next to your house? Is this something that you want next to your stream? Is this something that you want next to your wetlands? Is this something that you want next to your schools? And my clients in South Fayette Township and all of our clients got together and said, the fact that this power has been taken away from us as the people who know our community best, and the fact that the state has come and said, you are to ignore your constitutional obligations in terms of your rights to protect your environment and the health, safety, and welfare. The fact that the state has come and said that you no longer have any jurisdiction over this was not just mind-blowing to us, but it really made us feel like, has Pennsylvania gone in the wrong direction? Has Pennsylvania ignored its obligations to us as its citizens and to future generations? So when we got together, and as John said, we had never met before, we came to a meeting, we talked. The question was, how do we frame it so that people understand that this is about things that are much bigger than ourselves, and this is about more than politics. And part of what we did in putting together this challenge was we tried to make sure that there was something in it for everybody. Because again, it's not a left or right issue, it's not partisan, in that there is danger to all that all can see no matter where you sit on the spectrum. So we were very lucky, I would say, when we went for our injunction to get a senior judge, Judge Quigley, who was really on target and understood that if this law were allowed to come into effect and that an injunction was not entered, that the Commonwealth could never turn back. Because once the permits had been issued and once drilling had started and once these areas had been developed, and we had heard from very reliable sources that there were thousands of permits that were to be applied for the day after this law took effect, 120 days after it was passed. So the critical part of our first step, which we weren't even sure that we could go ahead and surmount, was to get an injunction and to stop that law from coming to effect. Because it's crazy, but in zoning, if you go ahead and you have permits and those permits are applied for and you go ahead and spend money on those permits and rely on those permits, you have a vested right, notwithstanding the fact that the permits or the laws could later be unconstitutional. So I think the point that I want to make sure everyone understands is the stakes on this are very real, and they were real from the beginning. And I think we had a wonderful wave of support behind us, but that first step was really a critical step in stopping the wound from even opening, because if we had not gotten the injunction, we would have been in trouble, because we could have had the success and there would be 5,000 wells already drilled and the damage would already have been done. We then went on a very expedited schedule. One of the other things I'll say about my colleagues who are amazing, and not just these gentlemen, but everybody who backed us up, is that the governor and the PUC and the DEP and at that point some senators and elected officials, everybody was pushing for an expedited fight. They wanted this to move as fast as possible. We too wanted an expedited fight. We wanted it to move as fast as possible because we felt the more delay, the more problems that we could potentially have, the more dangerous it was for our citizens, our clients. So we worked very hard to get to the Commonwealth Court, and in front of the Commonwealth Court, an en banc panel, which means all 7 judges were there. We had probably the most spirited and at least the most well-attended argument that they've ever seen. And in an opinion written by President Judge Pellegrini, which in my mind is one of the most landmark opinions ever to be written, and you know, President Judge Justice Castile wrote an unbelievable opinion which you know, raised the stakes, but I think we shouldn't forget how strong President Judge Pellegrini's opinion was. And he went back to the core of zoning and went back, and it was a 4-3 vote, and I would add 2 Republicans, 2 Democrats in the majority. He went back to what is zoning about, what is the core of zoning about, and why is it constitutional, which was the basis of our arguments on different levels. And that if you haven't done it in a constitutional way, the state, the zoning must fail, and if it hasn't been done in a constitutional way, the state doesn't have any right to do it in an unconstitutional way ever, either. And I would just say that this picture relates to one of the comments that President Judge Pellegrini made in his opinion, which was that if, you know, the proper place for the pig is in the barnyard, not in the ballroom. And that goes all the way back to the original Supreme Court decision on zoning. This was the majority opinion of the Commonwealth Court. And you know, when you think about it and you think, what is the proper place for this? It's certainly not next to somebody's house, next to somebody's school, next to any of those items. And we were thrilled with the Commonwealth Court decision, even more thrilled with the Supreme Court decision. And we moved very quickly to get this up to the Supremes, and again had a packed house. And I can't say enough about not just my colleagues, but the support we've had from the entire Commonwealth. You had 2,500 municipalities that joined us in one way or another to support us. You had elected officials. You had portions of caucuses in the state Senate joining us. We had a tremendous amount of amicus briefs filed. And what was really gratifying to us, and gratifying to us again this evening, which is part of the reason why we're here, is because people got it. So thank you to you for getting it, and thank you to my colleagues for, you know, putting us on probably what is the most significant path to, you know, the best decision for environmental rights in the country. So.
I think that was a wonderful introduction to the story that put us all in this wonderful place. We do have some questions, so I'm going to ask them, and if Christine's going to time for me. The first question is actually for you, Mr. Ball, and it asks how you overcame the political pressure of challenging a pro-drilling law in an area where there already was a lot of gas drilling taking place.
That's why we're here. How did we get around the political pressure? The pressure wasn't really so much political. It was financial. We had a huge financial interest that was impinging upon the right of municipalities to run their own affairs. So we didn't have to get around political problems. We had to get around the debate between the financial interests of the gas companies and the rights of our citizens. Does that answer the question?
Yeah. Do you have anything to add, John or John, for your communities or the other towns that you represented?
I think there was a tremendous amount of pressure, because I think part of the problem is that the debate had been improperly sort of set up at the beginning, right? So it wasn't a question of, am I taking somebody's drilling rights or am I in favor of schools? The question is what is constitutionally appropriate? And once the debate got out of control, I mean, we had 850 people at the meeting, and there was financial, the group of people who owned their mineral rights who were very much wanted to harvest them, and there was a group of people who sometimes had houses on proper land that they didn't own their mineral rights, and then other times had, other concerns. So it was a very, very tortured room with a lot of emotions, and I would say that there's still a lot of emotions about it.
It continues today. I mean, there's still, and just Monday night, Dave and I had a meeting, and somebody came in and complained about Act 13, that Dave and Peters Township challenged Act 13, and Dave very politely set him straight, and I was sitting on my hands and biting my tongue, because what I've done in other communities, the alternative is, do you want your community to act in a way that's violative of the Constitution? Because that's what you're complaining about when you say, let me go wherever I want. And Dave wasn't making a judgment call as to whether that was good policy. He took an oath, as he put up on the screen, to comply with the Constitution. And the Constitution said, I have a duty to protect, I have a duty to make sure that uses are comparable in comparable districts. And now, as we know from the Supreme Court, it's clarified the obligation to make sure people are entitled to clean air and clean water.
So another one of our audience members asked, what were the kinds of zoning mandates or zoning ordinances and setbacks that were being implemented in the communities that you are a part of, that you're working with, that were undermined by the Act 13 legislation?
Well, I mean, Dave, do you want to speak to that first? Because you put in place a law where drilling would take place, it would just go away.
We put in place an ordinance that's a little different than simply defining boundaries. It's called a Mineral Extraction Overlay District, where we define 15 areas in the township where drilling could conceivably occur. The criteria were that the property had to be more than 40 acres, it had to be on an arterial or collector or state road to allow access for heavy equipment, and that it was a conditional use. And that last part is what gives us the control of what happens. It doesn't say there has to be a 300-foot setback, a 500-foot setback. It says the well would have to go where it doesn't impinge upon other people's rights. That's how we addressed it.
And I think the other communities where John and I worked in is with the conditional use. The process under Act 13, what undermined it, is drilling was a permitted use. There was no opportunity for local communities to have a forum to be heard. You would make application, you would get a permit to drill, and the elected officials would never see you. There would be no forum for community members to come in. That was the clear undermining of every local law, no matter what it looked like. The conditional use process is that now, and what would have been knocked out, that you come before the board, you make a presentation, and the board can vote no. And that's what they didn't like. And so when the law was passed, the mantra was predictability. Predictability for the drillers. They need predictability. They need predictability. One of the first things I argued to the Supreme Court is when you give predictability to the drillers to go anywhere they want, you take it away from every other citizen in Pennsylvania who's relied upon predictability that their neighbor is going to look like them and be residential and not industrial.
Yep. I mean, one of the things that we did in our South Fayette is we went through a whole process of identifying sensitive areas. And sensitive was environmentally sensitive, it was sensitive because of traffic, it was sensitive because of schools or usage. And then we went ahead and overlaid various restrictions upon it so that you had only a few areas where you could conduct surface operations. But an important thing to remember about our ordinance is that though you could conduct surface operations in these areas, because of the horizontal nature, people still had rights, so to speak, throughout the township to go ahead and to have those extracted. But we were very careful. So, for example, we had a 1,500-foot setback from waterways. We had setbacks from schools. We had setbacks from structures in residentially zoned districts, and we only permitted it in their industrial uses. We only permitted it in generally industrial or commercial areas, and all of that would have been gone but for Act 13.
Great. So thank you very much to our first panel. Now I'm going to call up our second panel, second set of panelists. And Jonathan Kamen's going to stay with us. And we are going to welcome Jordan Yeager and John Dernbach. And our second panel is very wonderfully described as the Great Victory. So they have a wonderful challenge here to describe that. We've already introduced Jonathan Kamen. But again, we have two new panelists, so I'm going to introduce them. First, we have John Dernbach. John Dernbach is a distinguished professor of law and co-director of the Environmental Law Center at Widener University. John, as I mentioned earlier, he didn't actively participate as part of the legal team in the case, but in 1999, he published a two-part article on Article 1, Section 27, that the Supreme Court plurality cited to repeatedly. So we believe that he was vitally important in helping to actually craft from a distance the final decision that we did obtain. We also have with us Jordan Yeager. Jordan is a partner and a chair of the Environmental and Public Sector section at Curtin and Hefner. Jordan was recently recognized as a Pennsylvania super lawyer, and at the Delaware Riverkeeper Network, we really think he's a super lawyer. We think they're all super lawyers. In the Supreme Court case, Jordan led the charge on issues such as standing, and he was also the lead for developing, briefing, and arguing that Act 13 violated the Environmental Rights Amendment, Article 1, Section 27 of the Pennsylvania Constitution. And then, of course, Jonathan Kamen. So, gentlemen.
So, as Maya said, I didn't participate actively in this particular case. Jordan called me at one point a couple of years ago about these two articles that I had written, but I worked at the Department of Environmental Resources for about 12 years in the 1980s and into the early 1990s. And I worked in several different programs. I worked as a lawyer. I worked on the program side. And all over the department, there were posters of Article 1, Section 27. And the first two sentences of Article 1, Section 27 are just shown here. And there's the third sentence. And a lot of us thought that these were really nice words, but we were more than a little skeptical about how much legal significance they had actually had in the jurisprudence of Pennsylvania courts. And the skepticism was founded on two cases. One was a case that was brought immediately after the environmental amendment was adopted by I should say, a 4-to-1 vote of the citizens of Pennsylvania in May of 1971. Is a case where the Attorney General filed a lawsuit to attempt to enjoin the construction of a proposed observation tower that would be built on private land just outside the Gettysburg Battlefield National Park. Some of you may know about this tower. Perhaps some of you were in it before it was taken down some years ago. And the argument that the Attorney General made was an argument that if you were sitting on, if you look at the first sentence of the amendment, the argument was that the tower was going to interfere with the aesthetic and historic appreciation that people would get of the battle if they were standing, for example, near Pickett's Charge, the area where Pickett's Charge took place, and looked out and saw the tower. That would sort of interfere with their experience. The folks who represented the tower said, well, look, most people aren't trying to do that. They just want to get a quick sense of the battle, and they're done. And besides, if you're up in the tower, maybe you get a better sense of the landscape. And I described the facts a little bit because this is not the kind of case that if you've got a brand new environmental amendment that you want to bring that is going to convince everybody that absolutely you've got truth and justice on your side. The injunction was actually denied at the trial court level. And without getting into all the detail about it, it's led to sort of a long discussion that has been going on among judges and within the bar in Pennsylvania about Article 1, Section 27 as a grant of authority to government. Because after all, if the government used this to file a lawsuit, then that's maybe the way we ought to understand it. And that has led to a whole conversation about whether the amendment is self-executing. And Pennsylvania jurisprudence at the time the Supreme Court decided this particular case was that the amendment applied when the legislature said so. That was sort of the first line of cases. And when I was working at the department, that was how we all understood it. The second line of cases stems from a case called Payne versus Kassab that was decided in the 1970s, again, a little while after the Gettysburg Tower case. This is a case that was argued originally as a public trust case. You can see the second sentence behind me of the amendment. And the gist of the case was that a street widening project in Wilkes-Barre was going to cause the loss of a half acre of public park, probably about 3% of the size of the park. And what I'll share with you again is that this is not exactly the kind of case you want to bring if you want to impress on people how really serious the public trust issues are. Yeah, there's a little bit of a public trust issue there, but it's not the big case with the big facts that gets the court to understand what's really at stake. And the Commonwealth Court devised a three-part balancing test as a substitute for the text of the environmental amendment. So the status of Article 1, Section 27, at the time that I worked at the department and at the time that this case was, just before this case was decided, was that one, the amendment only applied when the legislature said so, and two, when the amendment applied, you applied a three-part cost-benefit balancing test instead of the text of the amendment itself. Now, there's some exceptions to what I'm saying, but that's predominantly how it worked. Now, when I left the department to go into teaching, the question that was in front of me was, well, what does the amendment really mean? What's really going on here with Article 1, Section 27? And I was encouraged, I should say, to think about this because a professor I had at law school, a fellow named Joe Sachs, who died this past Sunday and whose obituary was in the New York Times, was a prominent figure in articulating the public trust doctrine. And I thought, well, okay, let's see what the Pennsylvania version of the public trust doctrine means. Let's see what the environmental amendment means. And in summary form, in terms of the articles that I wrote, here's what I got. The amendment was championed by a state legislature named Franklin Curry. As a young lawyer, he had done title work, I think, for a savings and loan in Shamokin. And he had run across this deed in doing title work. This is a deed from 1905. I've got a copy of it here. And it contains, in 2 paragraphs, this long exception and reservation allowing the prior owner of the property to run their pollution through the streams on this property. So there was a legal right to pollute that was basically acknowledged and supported by the deed itself. And he's looking at this and thinking, well, you know, the coal industry did a lot of economic development, but it also did a lot of harm. And at the crest of the environmental movement, he had an idea of putting protection of the environment into the Constitution. And what he did, and this was adopted again in 1971, and what he did basically had 2 parts. One, the first sentence of the amendment gives the people a right to clean, and by the way, the term the people is located in every single one of the 3 sentences in the amendment. It says, 1, the people have a right to clean air, pure water, and to the preservation of the natural, scenic, historic, and aesthetic values of the environment. That is an environmental right in the public to certain values of the environment. And the second and third sentences create a trustee responsibility for public natural resources for the state, and basically says that the state has an obligation to conserve and maintain them, not just for the current benefit of current generation, but for generations yet to come. Now, I'm looking at the text of this, and I'm reading these things for the first time and going through the legislative history for the first time, and I'm seeing a view of the environmental amendment that I had never seen when I was working at the department. And it captured, I think, a paragraph from a poem by T.S. Eliot. And I love this line because I think it captures exactly what is happening with the environmental amendment. He says in a poem called Little Gidding, "We shall not cease from exploration, And at the end of all our exploring will be to arrive where we started and to know the place for the first time. And that's exactly how I felt when I got done writing those articles. But then, back to reality, the Commonwealth Court in the Robinson Township case says, well, look, yeah, there's an Article 1, Section 27 claim, but guess what? The legislature says Article 1, Section 27 doesn't apply, therefore there's no legal claim. And that was the dissonance that I felt about this amendment until the Robinson Township case got decided by the Supreme Court.
Thank you, Professor. So I had not been an environmental lawyer, and no one would have thought of me as an environmental lawyer until very recently. I did a lot of constitutional rights litigation, though. And when I started getting involved in doing municipal work, zoning was kind of the key way that municipalities carried out their functions, their governmental functions of protecting local residents. And you know, sometimes when you're looking to figure out what to do on behalf of a client, you figure what you should do, start with, is start by going and looking at the Constitution. Because that's you start with the Constitution, then you go to the statutes, and then you go to the regs, and then you look at cases about what cases have said. And so I had read Professor Dernbach's articles and recognized that Article 1, Section 27 really just hadn't been respected, but that we have an obligation to take the Constitution seriously. And we can learn something from conservative judges who say we should be constitutionalists and we should take the text of the Constitution seriously. And so when Act 13 got passed, what Act 13 did at its core was say to all municipalities, you have to allow this massive industrial activity in every zoning district. You don't have the right to decide where this industrial use will go, just like you have the right to decide where a nursing home will go, or where a school will go, where residences will go. But this particular industrial activity, you don't have a right to say where it goes. And so I represent municipalities that have very fragile natural resources, municipalities that are along the Delaware River. And part of what they do is they protect those natural resources. They do it through zoning. And when we look at the language of Article 1, Section 27, it uses the word, I'm going to correct the professor, which I don't think I've done before. It doesn't say the state, it says the Commonwealth. That the Commonwealth shall conserve and maintain them for the benefit of all the people. And in Pennsylvania, when we talk about the Commonwealth, we're not just talking about the state. And there have been Supreme Court cases that have made it clear that when we're talking about the Commonwealth, we're talking about all the agencies of the Commonwealth, and we're talking about political subdivisions. So municipalities, when we see the word Commonwealth in this context, and the courts have said it before in the context of Section 27, that doesn't just mean the state government, but it means municipal governments as well. And so from my perspective, when you have a state law that says municipalities have an obligation to allow this massive industrial activity in every zoning district, you're taking away the rights, the constitutional obligations that municipal officials have under Article 1, Section 27. As trustees of these resources, the Commonwealth, municipal governments, shall conserve and maintain them for the benefit of all people. If that means anything, it means that when municipalities are carrying out their zoning obligations, they have to respect that constitutional mandate. They have to respect that they have an obligation not just to allow for use of property rights, but they also have an obligation to maintain those natural resources for the benefit of future generations. And Act 13 took that away. And so that was the argument that we made at the Commonwealth Court. As Professor Dernbach said, the Commonwealth Court didn't buy it, which was not a terrible surprise because of what had come before. And when we were preparing the argument, there's a lot of people who said, as Professor Dernbach had noted, that including friends in the environmental community, you can't argue Section 27 because it's a dead letter. It doesn't really mean anything. But we had a very good team that worked very well together, that respected that we've got to pull together these constitutional claims as strongly as we can. Obviously, when we got to the Supreme Court recognized, I think in a way that's true to conservative jurisprudence, that the argument has merit. Because when we look at the constitutional text, and the Supreme Court spent a lot of time exploring that constitutional text, if it means anything, it means that Act 13 couldn't stand. So let me just quick run down what the major holdings of the decision were. First of all, it recognized, and we're going to talk about this a little bit more later, that environmental rights, the Environmental Rights Amendment wasn't just placed anywhere in the Constitution. It was placed in the Declaration of Rights section of the Constitution, which means that the rights that we have to a clean environment are rights that are on par with our political rights. So the rights that we have in free speech and the private property rights we have, which are at the, our core rights, that the right to a clean environment is on the same par and has to be treated the same way. The second thing the court recognized is that this is not a grant of authority to government. So this doesn't say to government, you can go out and do a bunch of stuff, because there's a concern that if you do that, that will trample other rights. But it's a limitation on what government can do. And so as we enact a zoning ordinance in a municipality, we are limited by this constitutional text. We cannot grant approval to a project that would unreasonably interfere with these constitutional rights. And so when the legislature acts, when the regulatory bodies act, when local governments act, they are limited in what they can do. And they, just like they can't take an action that would violate your First Amendment, your free speech rights, they can't take an action that would unreasonably violate your property rights, they also can't take an action that would unreasonably interfere with your rights to a clean environment. And the third thing that the court did, I think on a broad scale, is recognize that environmental rights, that to look at protecting environment, you inherently have to look locally. And what Act 13 tried to do was say there is one statewide standard and that it's appropriate to allow this industrial activity everywhere in your municipality, in every zoning district, with the same set of setbacks everywhere. And the court said that you can't protect the environmental rights of our citizens without doing a balancing and recognizing what the local conditions are. That happens at the zoning level. That happens through our municipalities in Pennsylvania. So the court looked at that, and once you recognize those elements and you try to hold Act 13 up to it, there's no way Act 13 can stand. And so three justices of the Supreme Court found that Act 13 was unconstitutional under Article 1, Section 27. The fourth justice, who agreed that it was unconstitutional, he didn't disagree with that reason. He adopted the reasoning of the Commonwealth Court, which was that it was unconstitutional as a violation of due process. The three justices that rested on Section 27 didn't disagree with that. They just didn't reach that. So those are the principal holdings of the court, and we'll have time to talk about what those implications are, and my esteemed colleague will talk about where we are now with the litigation.
You know, one of the things that I think is worth noting as we get into that is the arguments that we made, I think, were for the first time different arguments that the court had heard, and Jordan did lead the charge on the 27 arguments, but it's interesting because it took such a drastic action by the state to awaken this provision that had been dormant for so long. And in talking to a lot of our colleagues in the land use and zoning world, they all sort of universally think that had the state not overreached in such an unbelievable way, that this never would have existed, that this particular argument wouldn't exist. And I think that's really what's interesting about the plurality opinion, Chief Justice Castile's opinion, is that it's really an example of somebody getting it and standing up for what, against the law that had a way to forever change the Commonwealth. And what came down in his opinion was, and not to gloat, but we just didn't win. I mean, we won, right? So there were several provisions that the Commonwealth Court had passed on because they didn't feel the need to address them because the substantive due process argument had won today. But the Supreme Court, sort of recognizing the significance of what had happened in that act, sent back to the Commonwealth Court for further findings certain discrete issues that we had raised as well. And the reason why the court did that is because I think it perceived that if left sort of unfinished, if those portions of the act had not been tied up one way or another, that there could be room for more damage. And I think the court was looking for finality on certain issues that went back. So briefly, one of those issues, and it's really a remarkable issue, is there's a requirement in Act 13 that if there is a spill, that notice has to be given to the people who are on public water. Well, you think, of course, that makes perfect sense. Why wouldn't you want the people on public water to have notice? Well, if you peel back just the first layer of the onion, you would know that most of the places where drilling happens, the people aren't on public water. People are on private water. They have well waters. So it seemed to the Supreme Court, who mentioned it, I believe, 3 times, and seemed to us that, you know, this was an example of sort of we're saying that we're doing great things, but in reality, we're doing something terrible. So one of the provisions that's back to for the Commonwealth Court to deal with is whether or not notification is necessary to people who have private water systems. And again, it's just, if you realize that probably 90% of the places where these wells are drilled, the people are on private water, why wouldn't you want them to know? Why wouldn't you, as a DEP, taking your obligations seriously, say to those people, hey, there's a spill and maybe you shouldn't drink, bathe, eat, cook, shower, swim in a swimming pool with this stuff. Another issue that went back to the Commonwealth Court for a decision, and this is really remarkable. I do a lot of land use and eminent domain work, but as part of the rights given to the drillers in this case, or to people who are in the industry, is they have a private right of eminent domain. Well, that is completely contrary to just about anything that we've seen in eminent domain jurisprudence over the last 20 years. There has to be a public purpose, and the question is what is the public purpose if they have a right to condemn a neighbor's property for gas storage? Doesn't seem that there was really much of a public purpose there. And in terms of the court, again, looking at the overreach, the extent of the overreach, they said, well, that's really something you have to deal with. And now the PUC is taking the position that they still have rights to regulate the operation side. And as part of those rights, to the extent that they find municipalities who have ordinances, including zoning ordinances, that are contradictory to that, they have the right to withhold impact fees. So it's sort of like when we were talking about this and understanding their position, that we were in the twilight zone and this opinion never happened. So we look forward to going back and revisiting that, because if you've given the PUC the rights to take away your money, and by the way, there are attorney's fees provisions in there if they don't like your ordinance and your ordinance is challenged and somebody's successful, that there's a punitive nature to it as well. The PUC at this point is really trying to claw back, I think, what has been determined to be the fundamental rights of the citizens and the Declaration of Rights. And so we have had a great victory and we are excited about it, but I think it's important for everyone to note that the war is not over in terms of the way that the provisions of this act that have survived are being viewed and looked at, and we have a lot more fighting to do and intend to do it. So.
Great. Well, we have some wonderful questions here. The first question is, did you formulate your arguments such that they would appeal to a more conservative-leaning Supreme Court? And if so, how?
Well, I mean, I think I touched on it a little bit. I mean, the first is, and it came up very directly in the Commonwealth Court, where there was one judge on the Commonwealth Court who I knew cared deeply about the Constitution and thought that judges should stick to what's in the Constitution, and made the argument very directly that that's what you should be doing here. In the Commonwealth, in the Supreme Court, I think the Supreme Court really did accept the framing of it as a limitation on authority. And that to contrast it with what Professor Dornbach referred to in the early days of the litigation, where it seemed like it was going to be used as a grant of authority. The court, I think,
really did appreciate that when we look at it as a limitation on authority, that a limitation on government authority, that is a conservative approach to governance and to jurisprudence. So I think those two things, kind of the text of the Constitution matters and recognizing it as a limitation on authority, were arguments that appealed to conservative judges.
Yeah, I mean, I would say no matter what side of the spectrum you're on, there's something in here for everyone to hate, right? So if you look at, no matter what your lens is, and people just come with different perspectives. And I think that we were very honest in terms of the way that this act impacted you, no matter what your view of the world was. And I think that that's really, if you go back to the overreach that I talked about before, I mean, that's really the stunning thing about this act. No matter where you came from, there's something in there where you looked at it and you said, I can't believe that that's in this act. So I think there was certainly a framing, but keep in mind, this is a constitutional argument, and it had to be a constitutional argument because 99.9% of the jurisprudence out there on anything other than a constitutional argument makes us automatic losers. So I think what I would say is we just framed the issues honestly, and I think that the court received them honestly and looked at them honestly. Agreed.
And having been there to witness the arguments as they were presented to the Supreme Court, I really can say that the arguments were presented in a very clear way, in a very compelling way, and there was even some wonderful humor. And I remember the language being used that the government was giving a sack of gifts, like Santa Claus, to the drilling companies. So it was very, very effectively argued on a lot of levels. The next question we have is, why had the environmental amendment up until this case been so sparsely cited in environmental protection cases?
Well, I think the short answer to that is the two cases that I was describing before. What happened here is that these early cases convinced courts that the environmental amendment was anti-development, or if you weren't really careful about reining it in, it was anti-development. The Park Service had approved this tower on private land. It was going to be constructed by a private developer. The Park Service, you might think, would know something about how the tower might affect the park. The other case, a half an acre, street widening, probably for public safety purposes, it's the same deal. And you see language in court opinions, both these cases, where they talk about the amendment as being anti-development. I think one of the things that I took care to do in my articles was to point out that Article 1, Section 1 of the Pennsylvania Constitution protects property rights. Article 1, Section 27 rather, Article 1, Section 27 is environmental rights and public trust. And I said, so look, they're both in the Constitution, and as a matter of reading the Constitution, you have to treat both of them as equivalent. It's not property rights trumping environmental rights. It's not environmental rights trumping property rights. It's property rights and environmental rights together. The old name you give that is conservation. The new name we talk about the same idea in sort of a broader context is sustainable development, which is a term that I was interested to see, which I used and which the Supreme Court used several times. But I think part of what these folks were able to do in terms of how they pitched their arguments is they said, look, the environmental right and the property right of the petitioners, the plaintiffs, David Ball, others, this is the same argument. It's not environmental rights versus property rights, it's environmental rights and property rights.
And so somebody asked if there could be a little bit of an expansion on exactly what was the due process argument that the one justice seemed to go with.
Well, I think John spoke to it earlier some, but at its core, when you have zoning, you are establishing expectations. And for zoning to be constitutional, it has to be reasonable and it has to serve the health, safety, and welfare of the community. And the basic way that communities do that is by zoning by district. So we put certain types of uses over here, certain types of uses over here. We keep incompatible uses separate. When you do that, you establish a certain set of expectations in property owners. And what Act 13 did was disrupt all those established expectations and therefore undermine the whole legitimacy of the zoning regime that each community had.
Right, and the only thing I would add to that is that the important thing to remember about our argument from the zoning perspective is we allege and believe that the state had engaged in zoning.
Right.
So it's unique because other than arguably in the gaming cases, the state had not engaged in zoning before. The state told you where it was going to go, how it had to go there, and there was nothing that anybody else had to say about it. So it is a corollary to what Jordan said. The due process side was, if I'm as a local engaging in zoning, I have to have some facts. I have to have some hearings. I have to give some notice. I have to have people come and say, how is this impacting my right? And then ultimately, I make a legislative decision on it. Here, the state had done that with nothing. They had gone ahead, made these decisions in an arbitrary way and said, this is how it's going to be. So our fundamental tenet was that if we as locals have to act constitutionally in enacting zoning ordinances, the state is bound by the same obligations. If they're going to do it, they must do it constitutionally.
Great, so let's thank our second panel.
Our third panel, and it's the last segment of our presentation here tonight. And this segment is entitled, Where Do We Go From Here? You've met two of the panelists already. We have John Smith and we have Jordan Yeager. And joining them on this panel is Maya Van Rossum. Maya Van Rossum has served as the Delaware Riverkeeper and leader for the Delaware Riverkeeper Network since 1994. The role of the Delaware Riverkeeper is to give voice to the Delaware River and to provide the communities and those that depend on it a voice in every decision making at every table that could provide help or harm. Maya will discuss the Delaware Riverkeeper Network's experience as the environmental organization that took on Act 13 in this legal challenge, including pressing the Environmental Rights Amendment argument. Okay, so we're going to get started, and after this session, we'll have 5 minutes of questions and answers. Then we'll go into our 15-minute Q&A with all of the panelists.
Okay, thank you. Where do we go from here? In the first topic, the changed landscape for municipal officials. And we kind of touched upon it, because to understand the changed landscape, you have to understand the case that we've been discussing this evening. So what Jordan's talked about before and outside of this, and I'm surprised Jordan didn't go here, is that the court uses the word revolution. How many times, Jordan?
3
times in the opinion.
And not talking about us.
Yeah, right. That we were not the revolutionaries. That the legislature was revolutionizing what was going on in a bad way. So now the court didn't announce some new standard per se. The court clarified the obligations to local municipalities. They didn't create some new rule that says municipalities, you now have to do this. They just subtly reminded municipalities that these constitutional obligations exist, and they didn't so gently remind local or the state government that you cannot tell local municipalities to violate the Constitution, because that's exactly what Act 13 was doing, and the court was emphatic that that is not proper, nor should it be. Now, I put a slide up here, and this here is a municipality, obviously, in Pennsylvania. You see the homes next to it. You see the cows around it. But another quote I thought was appropriate to put this in some context. It says, to put it succinctly, our citizens buying homes and raising families in areas zoned residential had a reasonable expectation concerning the environment in which they were living, often for years or even decades. Act 13 fundamentally disrupted those expectations and ordered local government to take measures to affect new uses irrespective of local concerns. So now we're back for local concerns. And you have to look at the local concerns in terms of each municipality is different. Each municipality has different comprehensive plans, different ideas where a main street might go, different idea of where residential may go. And we've had hearings in the past in our communities where we have drilling, and we would ask the question, are you going to have emissions from your site? Well, yes. Well, how far will those emissions travel? And the answer is, and I think some of it we've quoted to the Supreme Court, well, that depends. and it depends on the local topography, the wind conditions. Who is going to be the receptor of those emissions? Well, that depends. Is it going to be a school? Is it going to be a housing development? Is it going to be other industrial uses? So one of our main arguments was when you take away our ability to protect our local citizens, and as Jordan pointed out, make some blanket assertion that 300 feet from everywhere is appropriate, that's wrong. So municipalities now have the obligation to go back, to make sure that their local ordinances exist, to protect people, to make sure they comply with Article 1, Section 27, that people have the right to clean air and clean water. And I think, having sat with the Commonwealth Court and having looked at the opinion, that the court more than likely also will look at the compatibility issues going forward with residential districts. Can you allow drilling in residential districts? The Commonwealth Court and the due process side pretty much said no, that those aren't compatible. That's why it's unconstitutional. Justice Baer agreed with that. I don't think, and I think my colleagues would agree, that the plurality disagreed with that. They just went further. So looking at the local ordinances, you have to protect and you have to maintain your residential areas to protect not only your individuals from a healthy environment, but also your tax base. Because what's lost in all this is that there is some great financial incentive to allow drilling, that the local governments are going to benefit. When you allow drilling everywhere or in a lot of places, you eliminate those places forever for future development. Miles of pipeline, 75-foot wide, right-of-way easements, take that area off the map. Drilling pad sites, as we had up before, often a finished site might be 5 acres. Compressor stations, frac ponds, all these issues, when you put hundreds of these in one municipality, how many of you are thinking, boy, I would like to live next to one of those industrial applications? And I have clients who live next to these industrial applications who have gone and had their property values assessed downward. And that affects the local tax base. We also, from a local government standpoint, get our taxes from earned income tax. Well, typically people of affluence aren't going to move into your area to live next to an industrial application. So, and if you have people that have significant or at least EIT, earned income tax, that can keep the viability of the municipality going, and they're going to sell their property, assuming that they can sell it, you're not going to have somebody typically comparable in scope in terms of what they make. You're going to sell it for people to lower value, lower EIT. And Texas is a perfect example. If you look at Denton, Texas, we've been in discussions with them. They said, we didn't realize we've let drilling go on so much, there's nothing left to develop. We have limitations on what we can do. One other thing that I will raise so we have to create local ordinances. Those are going to depend on the situation at the local communities. But definitely I would think that you can't allow permitted uses in all districts, as the court found the state law was violative of the Constitution. In our estimation, you should at least have a forum where you can have a hearing, where you can make an up or down vote on whether they provide enough evidence that they've complied with the constitutional mandate such that the board is satisfied. How do you get there? We talked about maybe the Council of Governments or municipalities pooling their resources and having experts, because you typically might have farmers or uneducated local government officials where drilling companies come in and provide testimony that it's safe, it's going to be fine, and there is no counter testimony other than people in opposition. It would be nice that the governments would have industrial hygienists, toxicologists, epidemiologists, where they could call upon and say, is that true? You know, have we done air modeling? Have we done water testing? Those are the features I think are now squarely in front of the local governments, and I would like to see that move forward. So, Jordan?
Great. I'm just going to get back to this notion that I talked about earlier. So I'm going to just address what the changed landscape is for environmental law. And in my mind, the biggest change that this does is really a mindset change. And if you look at the language in the slide, Declaration of Rights, so the Declaration of Rights is the first section of the Constitution. It's not where you grant authority to the legislature. Here's what the legislature can do, here's what the courts can do. It's where you are stating what the inherent rights in the people already are. So they're not created by the Constitution, they exist inherently, and they're just stated in the Constitution. So we only put those rights in that section, in the Declaration of Rights, that are inherent and are really at the core of what we're talking about. And so the Declaration of Rights assumes that the rights of the people, all those that are stated in there, including Article 1, Section 27, are inherent in the people, and because it's stated in there, it's on par with all the other political rights. And so that mindset is, I think, really, really helpful as we think about environmental law going forward. And once we recognize that the preservation of the environment has to be respected just as much for current generations and for future generations, as our free speech rights need to be protected, as our important private property rights need to be protected, as our rights to be free from discrimination and our rights to equal treatment. Once we recognize that the values that we hold in an environment are of the same nature as those other political values, it changes the way we look at the role of government, and we look at what the limitations are on government authority. And so when the legislature acts, it cannot act in a way that unreasonably interferes with those rights, just like it can't unreasonably interfere with the other political rights. And the court looked here at what the act did, which was really to propel the development of this industrial activity. And it said this isn't a law that is respecting the environment. This is a law that's encouraging the destruction of the environment. And that could not withstand constitutional challenge. So it took something that was as revolutionary and as destructive as Act 13 to get that jurisprudence established. But it is inherent in the Constitution, and it is something that we have to recognize, that the legislators have to recognize going forward in carrying out their legislative role, that they are limited by the Constitution and limited in protecting these resources for future generations. It also means that when the Department of Environmental Protection is granting a permit, that it's not enough for them to look at the regulatory regime that's established. It's not enough for them to look at the statutes that are there. They are only able to do what the Constitution allows them to do. They are limited by the constitutional text. And so that is going to be a reminder that the administrative agencies, the regulatory agencies, are going to be hearing time and time again going forward. And the same is then true at the local level, that when local governments are acting, they are acting as trustees of these resources, and they aren't just protecting the rights of people now, but they're protecting the rights of future generations. And so it's that balancing that is now, that the constitutional text that requires that balancing has now been elevated to the same par of the other political rights, I think is going to be the most lasting legacy of this decision.
The clicker.
Oh, the clicker, sorry.
Oh, boy. Oh, there you go. So I think Jordan and I are very much of the same mindset, and that makes a lot of sense because he was our legal counsel in this. But as we've heard this evening, there were a lot of important and powerful pronouncements that came out of the Supreme Court decision. But we at the Delaware Riverkeeper Network believe that one of the most important were the pronouncements by the court with regards to environmental rights. That the right to pure water, clean air, and a healthy environment are inherent and indefeasible rights. They are not rights that were given to us by the Constitution. They are rights that we have as a people that the Constitution simply acknowledged. That they are rights of present and future generations, and that they are rights that have to be protected by every level of government here in the Commonwealth. And so the question, with regards to how do we move forward, I start at the same place that Jordan began just now. We have to, as people, really embrace that concept. Embrace the concept that the right to a healthy environment is just that. It's a right. It's something that we should expect. It's not something that's a gift to us. It's not something that we should be grateful for when government actually does it. It is something that we are entitled to, and that we need to rise up and demand and defend when appropriate. I think also going forward, we need to go out into the world, we the people need to go out into the world and make sure that all of our government officials know what happened in this Robinson Township versus the Commonwealth decision. That they need to understand that they now have very clear obligations when it comes to environmental protection. When they are taking actions, when they are making decisions, they have to consider the impacts to our environment and our environmental rights in a very substantive and meaningful way. And more than that, they have to make decisions and take actions that actually protect our environment. So while they're striving to accomplish other valid goals, at the same time they strive to accomplish and they succeed in accomplishing protecting our environmental rights. Now, does this mean that the environment is always going to trump everything? No, of course not. We as a community have many important values, right? There are many goals that we pursue as a community, and many goals that we want our elected officials to pursue. But what it does mean is every time they are striving to accomplish one of these other goals, and they achieve in accomplishing these other goals, they have to also strive for and achieve environmental protection. So their decisions have to be about not one or the other, but how do we accomplish both at the same time? And I would say to you that you can always accomplish both at the same time, no matter what that other goal is. Also, as we sort of go out to the world speaking with our elected officials, we need to make sure that they understand that this Supreme Court decision is much more than being just about shale gas development. I think it's very easy for our legislators, our public officials, our agency representatives to say, well, it's Act 13. That was the pro-drilling law. Therefore, if I'm not talking about drilling, if I'm not acting in a way that has to deal with shale gas development, I don't need to think about environmental protection or the Supreme Court decision. And that's absolutely not the case. This decision is sort of an umbrella now over everything that our public officials do. If they're taking an action, making a decision that impacts our environment, they need to be thinking about and accomplishing environmental protection. I think it's very important that we don't assume that our elected officials are thinking about the Robinson Township decision or the Environmental Rights Amendment, or that they have any idea what has happened in these recent months. I think that it's very important that we don't make that assumption, that we affirmatively go out and educate our elected officials. And I think we have a very good example right now moving forward in the halls of Harrisburg to demonstrate to us that what I say is true, that a lot of our elected officials probably aren't aware of this legal decision, or if they, well, maybe this legislator is aware of it and just doesn't care, and that would be even worse. But we have moving through Harrisburg a piece of legislation where there's a memo seeking sponsorship, and this piece of legislation is absolutely designed to remove authority from municipal governments. And if this proposed piece of legislation were to become law, it says that whenever a Department of Environmental Protection permit is required and is granted for a regulated activity, the provisions of that DEP permit, quote, shall supersede all local ordinances and enactments purporting to establish standards for natural resources and environmental protection. You couldn't be any more clear violation of what the Supreme Court just threw out than that. If that proposal becomes law, it will prevent our municipal officials from fulfilling their constitutional obligations. It will also prevent them from fulfilling their obligations under a number of state and federal laws that require them to be the first decision makers on critical issues having to do with water pollution and air pollution, with flooding and stormwater runoff, with wastewater issues and with sewage issues. So we really can't we can't make the assumption that our legislators know what this Supreme Court decision was all about, and I think we can't assume that they all actually do care and are taking it to heart. I'm not sure what the case is with Representative Seth Grove, but who was the one moving forward that piece of legislation. But the other thing in moving forward now in the face of this new great decision we have, I think we want to be looking beyond the boundaries of just the Commonwealth of Pennsylvania. At the Delaware Riverkeeper Network, we really want this decision to serve as an inspiration for other states to craft and implement constitutional protections or constitutional provisions that protect environmental rights. We want to see that in every state across the nation, and let's even strive for it at the federal level. Because I think what we all know very clearly from experience is that while our rights to pure water and clean air and a healthy environment are inherent and indefeasible rights, unless they are protected at the very highest levels of our laws, like in our constitutional provisions, it is simply too easy for our lawmakers and our judges to set those rights aside, to allow them to become subservient to the goals of industry or politics or greed. And we simply can't allow that to happen anymore. And that is why at the Delaware Riverkeeper Network we are starting the Generations Project, because we want to make sure that this Supreme Court decision is honored here in the Commonwealth, but we also want to make sure that it serves as an inspiration for everybody else in this country to get this same high level of protection, because we really do know that environmental protection means good governance and it means good sense. And what I always say to communities when I speak with them, I don't care what your personal priority is. I don't care if it's family values. I don't care if it's education. I don't care if it's health and safety. I don't care if it's flooding and flood damages. I don't care if it's property values or child welfare. I don't care if it's the economy. I don't care what your personal value is for your community. What I can guarantee you is that on a community level, you will best accomplish that goal, that value, if at the same time you are striving to achieve it and do achieve it, you protect our environment. Oh, they did.
So we have several good questions here. Hard to pick out which ones to go with first, but I'll throw this one out. As a result of this decision, will there be additional cases testing the limits of other cases, such as leasing of state lands for drilling?
There are going to be new cases. There already are new cases. In fact, Jordan, John, and I are back up at the Commonwealth Court on remand, which will create a new body of law once that decision comes down as well. But as to the leasing on public land, it's a good question. We see it at the local level too, whether the counties or local governments should be leasing public property. And I think it is going to create a case, if it happens, from citizens using Article 1, Section 27 against governments for the very reason that they haven't taken into account all the issues from an environmental standpoint that they should have prior to entering into those leases. I will tell you from experience, prior to this decision, those are not questions that local governments or any government was answering. Everyone thinks that once the DEP issues a drilling permit that there is some health-based study or some air-based study involved. There is not. So the questions that are left open by Article 1, Section 27 to be answered have not been answered before when the government has been leasing.
And I'll just add that one of the things that the court did was made clear that that citizens, and it recognized the role of the people in the amendment, that citizens have legal standing to challenge when the government has violated those constitutional rights. So it certainly provides a platform, a recognition of that platform for when the government, if the government, for example, continues to allow leasing and doing it in a way that violates the public trust. The court has certainly provided a roadmap for those kinds of issues.
Do you think that Governor Corbett and Pennsylvania DEP recognize yet that they did overreach?
I think it's very clear that they don't recognize that they've overreached. As we've moved forward since this decision, they've made a lot of excuses for why drilling is good for the Commonwealth, why it should be allowed to continue to go forward. They seem to be looking for other strategies to open doors for shale gas development. I would not at all be surprised if the Seth Grove legislation that I mentioned is not part and parcel of some grand strategy to try to find another way to pry open the door. We've even had where recently there was an explosion in which a worker died and a home about, I think it was about a half-mile away, didn't get destroyed. But we did have somebody die and have this catastrophic event at the drilling well pad. And the Secretary of the Department of Environmental Protection said, oh, thank goodness that there wasn't a house nearby, and yet really failed to acknowledge that if Act 13 had been allowed to stand, if we hadn't brought the legal challenge that pulled out critical provisions of the Act, that house could have been 300 feet from the well pad, from the frack pit where this explosion took place. So it's sort of this very hypocritical perspective that, we're going to thank goodness that by luck of the draw a house was far away, while not admitting that if they had their druthers, the house could have been almost spitting distance away.
Former DEP Secretary Michael Krancer has stated one implication of the decision is that people will now sue townships that do not have zoning restricting gas drilling. Do you agree with that? And how is this, could this possibly be an approach for citizens in townships that don't have zoning?
Let me start with
Well, we're battling over who gets to talk about Secretary Krancer.
Yeah.
Go ahead.
Secretary Krancer, again, ahead of the DEP, advocated for drill sites 300 feet from people's homes. So let's start with that premise. Secondly, the idea that municipalities could be sued for violating their citizens' constitutional rights is nothing new. It fits in every circumstance where there are, if you deny somebody's free speech right, you can sue your local municipality. If you ban guns, you can sue your local municipality. If you deny them clean water and clean air, guess what? You can sue your local municipality. So he's right in that respect. And quite honestly, if a local government doesn't do its job, it very well should be sued.
You want to add to that, Jordan?
Well, Secretary Krancer, former DEP Secretary Krancer is an attorney for the fossil fuel industry, and he's doing what he can to promote that practice. And so part of that, as it's always been for him, is to scare people. But John is right that any governmental entity that violates the Constitution has always been subject to challenge.
What does this decision mean for the impact fee that was in Act 13?
It means, at this point, it's pretty clear that it doesn't mean anything for the impact fee. The impact fee section of the law hadn't been challenged by us, and at this point, nobody is suggesting that those portions ought to be enjoined along with the rest of it. We do expect that the Public Utility Commission is going to try to continue to carry out a role under Act 13 to deprive municipalities of those impact fees. It's our position that they were enjoined from doing that, so we're still going to have to debate some of those issues.
And I would add to that, that is back on remand before the Commonwealth Court, that issue. And there's only really been 4 instances where the PUC has dealt with ordinances that have been challenged to deny impact fees. Of over 3,000 municipalities, 4 instances. Of those 4 instances, there were 4 of the plaintiffs in the Act 13 case.
So do you think it's punitive then? Or?
Well, that was raised by Mr. Kamen, sitting in the audience, that it was. Judge Quigley enjoined denying John close to $1 million to the Act 13 plaintiffs in impact fees who had a lot of drilling going on at the time.
What's happening with the medical gag order of this case? And this will be our last question under this segment.
So at the Commonwealth Court had said that the doctor who brought that claim didn't have legal standing to do that. The Supreme Court reversed the Commonwealth Court on that, so the Supreme Court said, yes, the doctor has standing. The doctor is faced with a position where he either takes a patient and has to abide by the law, or turn away patients, or take a patient and therefore abide by the law and violate his ethical obligations. So the Corbett administration is still defending the physician gag rule. It is now back. It's one of the things that we'll be litigating on remand.
Thank you. So this is the end of the segment for questions and answers for this portion of the panel tonight. However, everyone is going to come up who's been on the panel all evening. We're going to put a couple more chairs up here, and we'll have 15 minutes of Q&A. We have a lot more questions. People are sending them in by internet, and please feel free to hand them to one of our staff walking around the room if you have anything you'd like to add.
Just a reminder, if you are out in the ether world, questions@delawareriverkeeper.org is where you can submit your questions electronically.
David Ball, Jonathan Kamen, John Smith, Jordan Yeager, John Dernbach, and Maya Van Rossum. So we have a lot more questions here, and please continue to hand them to our staff. Can individual property owners now have the opportunity for legal representation with Act 13 decision to keep drilling out of their townships and stop the permitting of wells on neighboring properties?
I'm not sure that I understand the question.
I think they're asking, can individual property owners actually now keep drilling out of their townships completely?
So it ultimately boils down to a question of standing. And standing in this situation would be, how are they negatively affected? I think they've always had standing, and I think the decision of the Supreme Court confirms that if they are negatively affected and their rights are violated, as we've discussed, then I think they absolutely have a right to bring an action to challenge, just as they would challenge any other municipal action that they had concerns with.
And I think what will happen is at the local level, now that the power is back before the local boards, there will be a hearing process where that affected neighbor would come forward and offer evidence saying that they are aggrieved and putting in evidence as to why the board should deny the application of that particular drill site. So with Act 13, those provisions going away, that individual has a forum now for which to begin his case at the local level before drilling ever begins.
How about the second part of that question about keeping drilling completely out of a municipality? Can that happen?
I think that's going to be a challenge for the vast majority of municipalities. The zoning, the basic ideas of zoning have always been that municipalities have to allow for a variety of uses. You can't have a municipality that is just a resource protection zone. You can't have a municipality that is just residential and keeps out all industrial. So I think it's fair to say that each municipality is going to have to continue to strike a balance. And I think a municipality is going to be vulnerable to challenge if it tries to do a complete ban. It may be possible in certain unique circumstances if the way the municipality is already built out, the resources that exist there, that it could happen. I wouldn't want to rule out, but you have to look at it municipality by municipality.
Does this decision mean that an environmental impact study will be needed for all government actions in Pennsylvania now?
Well, I think there is, as a public, when you're carrying out a trustee obligation, you're acting as a fiduciary. When you're acting as a fiduciary, it means you can only make decisions that are informed. And so if the legislature makes decisions that degrade that trust, the corpus, the body of the trust, and have done it in a way without having been informed, as it happened here, they're subject to challenge. The court here specifically noted the absence of a real assessment of what the impact would be on a local level in striking it down. So certainly the absence of that is going to make any legislation more susceptible to challenge.
The first forced pooling DEP public hearing is about to take place in Lawrence County in Pennsylvania. Is there any way to challenge forced pooling on the Utica formation on the basis of the Act 13 ruling?
You know, I've talked to the people in Lawrence on this issue, and what it is, the forced pooling is in the Utica formation. Am I down, Jordan? I'm good. In the Utica formation, even in the prior Oil and Gas Act, there's a certain depth, and I can't think of the depth right now, but in the Oil and Gas Act, if you reach a certain depth, and that's your target strata, then you can have forced pooling, meaning you can be forced into that drilling unit. That's never, it's always been the law, but it's never been an issue because nobody's ever gone that deep. There was never reason to go that deep. Now there is reason to go to the Utica formation below the Marcellus, which just so happens to fall in a strata that allows forced pooling. The case initially went to the Environmental Hearing Board. Environmental Hearing Board put it back to the DEP, said it's your job to make the first decision as to whether or not this particular operation of forced pooling is legal. Now, as to the Act 13, these people will be forced in, and it's probably more to John as to whether or not this is an eminent domain. You are giving the drilling industry the power to take from these particular people.
Yeah, I think that, as John said, the issue has been there, but it's never been ripe. The issue is now ripe. In my mind, the whole concept of forced pooling is ridiculous. So, it's probably the best legal way to describe it. It's ridiculous because you are taking somebody else's rights taking their property rights without just compensation or public purpose for it. Now, there can be argument as to just compensation. I don't think there's a whole lot of argument for public purpose, but I do think that the Act 13 part that remains, the eminent domain part that remains, will have some bearing as to what rights you're giving to somebody else to compel forest pooling. So I think this case very much is going to set the stage on it.
ACRE, Act 38, has been in place since 2005. This Pennsylvania Act overrides all municipal control of anything that Harrisburg deems farming, including where high-density animal operations called confined animal feeding operations are placed, or where sewage sludge is land applied. ACRE also uses Pennsylvania tax dollars to have the Attorney General sue any municipality who tries to regulate, similar to what was in Act 13. How does the override of Act 13 relate to Pennsylvania laws already in place?
The court was clear that simply because an argument hasn't been made before doesn't mean it can't be made anew. And so when you look at a law like the law that allows for industry to utilize the Attorney General to sue municipalities, to force municipalities to allow the dumping of sewage sludge throughout their communities, it certainly looks a lot like the problems that the court was concerned about in the Robinson Township case.
If I can just add one thing, a former student of mine works on ACRE for the Attorney General, and we had this exact conversation several weeks ago, and she thinks ACRE is distinguishable.
Very well. You know, I would just add, in our arguments, we did distinguish ACRE. And we don't need to get into it now, there's a whole reason why, but I haven't thought about how Act 13 implicates it.
Can citizens of Pittsburgh file a lawsuit against Allegheny County Council for leasing Pittsburgh airports and possibly leasing Allegheny County parks because of the Act 13 ruling?
And Jordan's probably best to speak to this.
I'm not from Allegheny County, though.
But I think the issue is with the public trust, and it is an Article 1, Section 27 issue. Have you done your homework? Have you made sure that what you're doing is going to preserve the land for future generations? As the court said, it doesn't mean you can't use the land. There has to be some balancing there. But the question of, let's assume they're going to drill on private lands or state lands where we do have drilling. Have you looked at what it's going to do to the ecosystem? Have you looked, and if you went to court, could you put studies before the court and said, look, we had industrial hygienists look at this. We had a number of biologists look at what would possibly be the effects of drilling in these areas. And if it is reliable and if it makes sense, then like any case, you would think that that is a reasonable action. The lack of that information may in fact cause counties or governments to be sued for leasing land.
Right, and just to punch up what John said, I think the interesting thing about the Supreme Court decision is they found it to be revolutionary, as we talked about, in terms of the lack of due diligence that was done by the legislature in this matter. And I think what they're saying is that ultimately it may be a legislative decision, but there has to be this dialogue, there has to be this study, this investigation. And I think it's a case-by-case basis as to whether or not what they've studied and the evidence supports the decision that they made.
And I just want to add that while it can be difficult and it can be very expensive, it's important that we as a community not allow the consideration of environmental impacts in the decisions that move forward to be one-sided, where the legislator is going out and asking their public health official or their environmental officer what their opinion is, or their own hired expert about what their opinion is about allowing a certain activity, allowing shale gas development to happen on public lands. It's really important that we as a community are putting forth the credible science that is out there in the world demonstrating, documenting how devastating shale gas development is to our natural resources, is to the health of peoples that are nearby, far by, the impacts for global climate change, so that as our public officials become a little bit more savvy about this Supreme Court decision and start to give some consideration to environmental impacts, that it can't be a lopsided conversation, and that we make sure that it really is an informed dialogue with all of that wealth of science and experience that is out there in the world today.
And I think, just to add, noticeably absent in Act 13, which was very problematic, is that the State Department of Health was not consulted in drafting this particular law. So we're talking about, are you doing your due diligence? Are people going to be affected from a health standpoint? Is their air going to be affected? And you did not consult with the specialists or experts who could weigh in on that issue, and you did it anyway.
A question on civil suits, such as the Cascade and Haney cases, where they've claimed physical harm, especially Haney and her 3 children. due to negligence by drilling companies. Will the court permit total transparency to the press of this health impact due to this court finding? Will there be an impact, fallout from that?
You know what, I am counsel in both of those cases, and I can't really address that because it's in litigation, so.
Anybody else want to give an opinion on that?
Not without conferring with Mr. Smith.
Do we anticipate that Governor Corbett or perhaps the legislature will recraft a similar act to subvert this ruling? And if so, how? Maya mentioned one in her presentation. How do we think that this may be undone by the legislature?
I don't think anybody here wants to give any ideas to.
Well, I can say that I know that it's already happening. So I know that there have been meetings, I know that there have been discussions, and I'm not sure if it's the governor's office or it's other members of the General Assembly who are pushing it, but there is definitely a push to have a new legislative response to it that perhaps doesn't overreach as much. But I think the important thing for us to remember is that the sleeping giant has been awoken, right? So I think that there is a new affirmation of their responsibility to us as the citizens to make sure that there is weight given to where there was no weight given before. But I think it's already, I know it's already happening. I know it's going, and I would say it probably won't happen until after the election, but I think we would be foolish to think that there's not going to be a General Assembly response.
I think, too, that, you know, while there's probably no appetite this year, or maybe even next year, for this because of the breadth and the specificity of the ruling, and I think that any other legislation would have to certainly take cognizance of the fact that Justice Castile was really, really specific. I mean, he didn't mess around in the decision. So, yes, you know, John's right that there's probably a lot of things being contemplated, but I suspect it's being done rather cautiously. But don't go to sleep.
Can I just add, I think that the appetite from the public to allow shale gas development to continue is shrinking, right? And that it really is very important that we take this time to make sure that all of our communities are fully informed about the devastation that happens when shale gas development is allowed to come into your town or the neighboring town or 5 towns over, and that we get into office elected officials who will not stand for that kind of an initiative, will not stand for legislation that's going to, you know, open the door wide and lay our communities bare to this industry, so that even if Governor Corbett or you know, some other governor in office wants to make the attempt, they won't have the legislators in office that will allow it to happen. So we have a moment, right? We have a moment to further build our cause. Let's take advantage of this moment.
There's a number of bad bills or anti-environmental bills that would have negative environmental impacts moving through the legislature right now, such as SB 411, which would incentivize the use of acid mine drainage and fracking. Also, the weakening of the Endangered Species Protection Act in Pennsylvania. Is there any hope that these bills perhaps will not gain the votes that they need to pass because legislators are beginning to think about Act 13 and implement it into the way they do their business in Harrisburg? Or do we have to look forward to perhaps legal challenges on every bill that goes through that has these negative environmental impacts?
I think there's great hope, because with both of those proposed pieces of legislation, there is an overwhelming response from the community saying to legislators, don't let this happen. And we are using the Supreme Court decision to inform those discussions increasingly. We are bringing forth the science and the experience and the legal arguments as to why these bad pieces of legislation should not be allowed to move forward. But I can also tell you that while the community is fighting hard to make sure that we get all the no votes necessary to prevent those bills from becoming legislation, that there are those of us prepared to stand up and bring the legal actions necessary to resist them if they do pass. So I think, you know, we have both opportunities, and we're going to take advantage of both of them to the extent we need to.
Well, the final question for the evening. Do you see the Pennsylvania decision and its reference to the public trust doctrine influencing or providing persuasive authority to other states grappling with natural resource development issues?
Yes, that's easy. A couple of weeks ago, not too many days actually after this opinion was issued, it was brought up in oral argument in a case before the Oregon Court of Appeals. I've talked to 3 separate people who have talked about, who've been in South Africa for different reasons, talking about constitutional protection of the environment, and the opinion has come up in at least 2 different venues. So I don't have too much doubt of that.
And Dave, I know Dave Ball spoke to the counsel that argued the recent Ohio case. Dave, if you want to talk about that.
Yes, Ohio argued a case that sounded vaguely similar to ours not too long after our decision came down. So I talked to the counsel who argued the case. One of the things he pointed out is that the Ohio Constitution is considerably different from Pennsylvania's in the way that it structures the balance of powers between municipalities and the state. So I think the message was that this will be discussed in many, many different places, but probably in many, many different ways. But what I hope all these places take from it, which was what this fellow from Ohio told me, was that they were heartened by the fact that our Supreme Court recognized the issue and dealt with it so directly. And in fact, he cited in his argument the Commonwealth decision because it was closer to the argument that he was required to make. So I think it will show up in a lot of places, probably in very different forms.
Thank you. Well, on behalf of Delaware Riverkeeper Network, I'd like to thank you all for joining us here tonight, and thank you online for those who are participating there. And those here in the room, I'd like you to come on out down the hall and join us for some refreshments afterwards. Thank you.